Two exciting panels. We are going to continue with the third one, that it's development, foreign and direct investment, and investment protection treaties. So I'm going to introduce you to Belén, who is going to be the moderator of this panel. She is currently in charge of the alliances with academic institutions in the United States in order to facilitate knowledge and technology transfer. She is currently the head of International Cooperation Unit in the Embassy of Ecuador. She has an MBA in small and medium-sized enterprise development in the University of Leipzig in Germany, and previously studied business management at the Catholic University in Ecuador. She has experience in the private sector development in Ecuador and Central America, and she was manager of an innovation fund in Ecuador, Innova Ecuador, and was innovation advisor of the Ministry of Agriculture. So, Belén, please.
Thank you very much. Welcome to this panel. Foreign direct investment has the potential to contribute significantly to sustainable economic development and break dependence through the transfer of capital and technology, job creation, economic linkages, infrastructure development, and capacity building. Accordingly, governments use a variety of tools and strategies to attract and retain investors. At a national level, governments have developed investment frameworks and industrial policies to maximize the benefits of investments. At an international level, a network of over 3,000 bilateral investment treaties has also developed in the past several decades to provide substantive and procedural protections and rights to investors as a means of encouraging and facilitating more investment. Nowadays, with some decades of experience with these national policies and bilateral investment treaties, there is evidence that these policies have not been effective at attracting the type of quality investment that produce the economic growth and development sought by host countries. Moreover, these tools can impose costs that further undermine the intended benefits and at times the policy space of governments to pursue development of objectives through other means. Together, these potential cracks in the chain leading from FDI to sustainable development are prompting governments to take a hard at their laws and policies for attracting and benefiting from foreign investment, and to focus renewed attention on how to best leverage domestic industrial policies and international investment law to catalyze and shape economic activity. This panel, Development, FDI, and Investment Treaty, seeks to facilitate a thoughtful conversation and discussion of policy solutions based on the analysis of foreign investment and the domestic and international frameworks that govern it. Let me introduce you to the three persons that are joining me today. First of all, I will start with the ladies. Liz Johnson. She is the senior legal researcher at Columbia Center on Sustainable International Investment in Columbia University. Liz is a senior legal researcher at Valley Columbia Center on Sustainable International Investment, a joint center of Columbia Law School and the Earth Institute of Columbia University. Her work centers on analyzing treaty-based investor-state arbitrations and examining the implications those cases have for the host countries, domestic policies, and development strategies. In addition, she concentrates on key institutional and procedural aspects of the legal framework, including efforts to increase transparency in and legitimacy of investor-state dispute settlement. She has a BA from Yale University, JD from University of Arizona, and LLM from Columbia Law School, and is admitted to the bar in California. Prior to joining the VCC, she was a legal consultant for the International Institute for Sustainable Development and a fellow at the Center for International Environmental Law. She also spent 4 years as a litigator at the international law firm Gibson, Dunn & Crutcher, representing clients in a variety of environmental, commercial, and regulatory matters. The gentleman at my right, Julián Garato, he's an associate in law, Columbia Law School. He's also a postdoctoral research scholar and lecturer in law at Columbia Law School. Julián Arato's scholarship draws on his background in law, history, and political theory, bringing public and private international law. His current work in progress examines the lawmaking capacity and autonomy of the multinational corporation under international law, particularly in the context of treaty regimes for the protection of international investment and human rights. His recent publications have focused on international investment law and international arbitration, public international law, constitutional theory, and the law of international organizations. And finally, Gustavo Dominguez, he's advisor on legal and environmental affairs. He's a consultant right now at the Embassy of Ecuador in the United States and has been a consultant for several Ecuadorian agencies. He obtained a Bachelor of Economics degree from the Universidad Vicente Rocafuerte of Ecuador and is currently a candidate for a law degree. He also holds a Master in Business Administration from the Instituto de Desarrollo Empresarial in Guayaquil, Ecuador, as well as a Master in Science of Foreign Service from Georgetown University. Mr. Dominguez has diplomas in nonprofit management from Georgetown University and government and political leadership from the Government School of the Instituto de Desarrollo Empresarial of Quito, Ecuador. So after that, I will give you the...
Actually, I will
you will
start.
start,
Yeah,
okay.
all right.
Okay, so.
Okay, ready? Thank you, Belén. Thank you for that introduction. I would like to start this presentation highlighting two statements and one recommendation made in August 2010 by 76 law professors from universities around the world that include universities from Canada, Singapore, United Kingdom, Australia, United States, China, South Africa, Russia, Germany, among others. The statement includes as general principles that foreign investment may have harmful as well as beneficial impact on society, and it is the responsibility of any government to encourage the beneficial while limiting the harmful, as well as states have a fundamental right to regulate on behalf of the public welfare, and this right must not be subordinated to the interests of investors, where the right to regulate is exercised in good faith and for a legitimate purpose. Two of the recommendations of that academic statement argues that civil society, and I will add sovereign governments, should continue to take steps to inform its constituents and society at large of the failures of and threats posed by the international investment regime, and to oppose the application of that regime to governments that undertake legislative or general policy measures for legitimate purposes. And the second and most important recommendation says states should review their investment treaties with a view to withdrawing from or renegotiating them. In light of the concern expressed by several governments and civil society, they should take steps to replace or curtail the use of investment treaty arbitration and should strengthen their domestic justice system for the benefit of all citizens and community, including investors. And the reason I decided to start the presentation with these academic statements and recommendations is because Ecuador implemented them many years before the academic public statement was made public. But as the Ambassador Celi said this morning, Ecuador did not arrive at this conclusion easily. The path to get to where we are today was long, litigious, and costly on many levels. For decades, transnational corporations took advantage of our country's institutional weakness as related to the public sector and of the lack of international obligations for corporations to comply with human and environmental rights, and deep external technological dependence by developing countries on foreign companies who abuse the trust afforded to them. Irresponsible extraction of natural resources, inadequate methods of remediation, and lack of financial compensation for victims of corporate responsibility harm not only the human life, but also the environment. Arguably, the most egregious example is that of Texaco Chevron, almost 25 years operation in Ecuador. This relationship with Texaco provided many lessons for Ecuador and the world in a number of different fields, particularly on human rights, investment treaties, international relations, business ethics, international law, and international arbitration. Now, for a matter of time, I will try to briefly present the Chevron case. Between 1990 and 2006, Ecuador signed 26 investment treaties. In 2008, Ecuador approved a new constitution, becoming the first national constitution in the world to enshrine the rights of nature. However, the same constitution, in its Article 419, states that the ratification or denunciation of international treaties will require the prior approval of the National Assembly in several cases. One of the cases is when bilateral investment treaties attribute competences of the domestic legal order to an international or supranational institution. The approval of the Constitution automatically requires the withdrawal of investment treaties. On September 23, 2009, 17 months before the Ecuadorian courts reached any final judgment in the Chevron Lago Agrio litigation, Ecuador was notified of a third arbitration proceeding before the Permanent Court of Arbitration at The Hague, requested by Chevron. On 2010, the Constitutional Court of Ecuador declared 3 articles of the Ecuador-United States bilateral investment treaty unconstitutional. Up to 2013, Ecuador has been involved in 36 international arbitrations, and CATISA, a special commission appointed for auditing the bilateral investment treaties and matters of the international system of arbitration, started to work. Out of the 26 bilateral investment treaties signed by Ecuador, 21 have been already denounced. 9 of the investment treaties have already finished the process of withdrawing. Up to 2014, Ecuador has 16 active cases of arbitration, 6 being with oil companies and 3 with mining companies. The litigation with Chevron and Occidental are the most important ones for Ecuador. Ecuador also has 5 notifications on controversy in process. 2 notifications are from oil companies. One of the most, if not the most controversial cases on investor state litigation is the Texaco Chevron case. The allegations of Chevron against the Republic of Ecuador are that Ecuador breached the bilateral investment treaty with the United States, that Ecuador and Petroecuador are exclusively responsible for the sentence in the judgment of Lago Agrio, that Chevron has no responsibility for the environmental damage in the Amazon after its operations in Ecuador, that Ecuador must hold unaccountable to Chevron in relation to the trial of Lago Agrio, and finally, compensation for moral damage. The Republic of Ecuador's arguments include that Ecuador has not breached the bilateral investment treaty with the United States, that the dispute between Chevron and Texaco and the community in Lago Agrio is a trial in which the state is not a part, and that in the release agreements between Ecuador and Texaco does not exist any obligation by Ecuador to maintain indemnify protected to Texaco, or that Ecuador has to defend Texaco against claims by third parties. The problem that we have in international arbitration is the fact that bilateral investment treaties commit states to lofty words and phrases without any discretion as to what those phrases actually mean. Ecuador sustained that the extensive tribunal interpretation of the United States-Ecuador bid has many errors in the interim award as well as in the partial award. Texaco left Ecuador in June of 1992. The treaty entered into force 5 years later in 1997. The treaty expressly provides that its terms apply only to investment disputes existing as of or arising after the day the treaty entered into force. The treaty's non-retroactivity provision reflects the fact that the state entered into the treaty to encourage future investment, not to grant rights to those who are already doing nothing for its economy. By exercising jurisdiction at all in this dispute, the tribunal dashed the state's contractual expectation. This was not what Ecuador had bargained for in 1997. The tribunal granted an interim award instructing the state, including its courts, to take all necessary measures to prevent the enforcement of the judgment issued by its courts in favor of the indigenous plaintiffs. State judiciary is perhaps the paramount symbol of sovereignty. The tribunal not only reached the conclusion that it has jurisdiction over the dispute, but it had the authority and power to order the domestic courts of a sovereign state to suspend enforcement of one of its judgments. It reached this conclusion notwithstanding that, first, the indigenous plaintiffs brought this action 20 years ago. Second, the court found that the pollution for which the defendant has been held responsible continues to cause the indigenous plaintiffs harm, threatening their lives, and third, compliance with the interim award will violate Ecuador's commitment under various human rights conventions. The tribunal more recently determined that the 1995 settlement agreement among the Republic, its state-owned company, and Chevron prohibits the plaintiffs from obtaining any remedy pursuant to a provision under the Ecuadorian Constitution guaranteeing the citizenry the right for a clean environment. The tribunal reached these conclusions on the basis that enforcement of such constitutional provision is a right belonging to the state, and then the state released such claims as part of the 1995 agreement. The state is surely a part to the settlement agreement, and is just as plainly cannot sue on claims that it released. The indigenous plaintiffs, however, are neither a party to the treaty nor to the settlement agreement, and just as plainly could not have released any claim against Chevron. In ruling as it did, the tribunal ignores the fact that under Ecuadorian law, the government cannot settle claims on behalf of the citizens. No party has the power under Ecuadorian law to settle any other party's claims, most especially when the rights at issue are fundamental rights granted by the Constitution. It will take 3 more minutes. Criticism of the state investor dispute system is rapidly increasing. The criticism is largely due to investors who often abuse these arbitration systems, either asserting that governments violated the bids because public policies had threatened their revenues, or by claiming that they were unfairly or unequitable treated when due process did not find in their favor. More and more, the international community and the academic world realizes that this broken arbitration system weakens the sovereignty rights of countries to conceive and implement public policies aimed at improving health, the environment, protecting human rights, and other social protections for their citizens. Recommendations including a most transparent selection of the arbitrators, the establishment of appeal instances, or exhausting local remedies before arbitration are more and more common among states and academics. Just from the lessons learned by Ecuador, not only the Republic of Ecuador, but also the developing economics and the academic community have made several recommendations that could better off the system. International organizations should refrain from promoting investment treaties and should conduct research and make recommendations on the serious risk posed to governments by investment treaty arbitrations. On preferred alternatives to investment treaty arbitration, including private risk insurance and contract-based arbitration, and on strategies for states to pursue withdrawal from or renegotiating on their investment treaties. The international community, members large and small, must change the ways that corporate social responsibilities measure. It must value human rights no less than it values profits. After all, the Amazon indigenous people started to fight for justice only a few months after Texaco finished its almost 25 years old operation. and they are still fighting, while polluters and its lawyers seems to be celebrating. Thank you.
Thank you very much. Okay, so let's go, Liz.
Okay, great. So, and I think Gustavo's presentation really highlighted some of the specific challenges that have arisen with investment treaties and some of the critiques that have been made of them. And I want to back up a bit and talk a bit more about investment treaties and what they are, and then some of the research that I've done looking into the tensions between investment treaties and domestic law and the extent to which they really pose a problem for policy space and the government's ability to take measures in the public interest. So in terms of investment treaties, now what they are, really, there are about 3,000 of them worldwide, and they're instruments concluded between governments. And one justification for them is the idea that they will lead to increased foreign investment, with the idea that that investment in turn will lead to sustainable growth and development. Whether or not investment treaties actually do lead to increased investment, I think that's increasingly open to question. The data is very inconclusive on that. But that was one of the reasons why they're concluded. And what they do is they provide certain rights and protections for foreign investors. And if the government receiving the investment, which we call the host government, does something to breach the treaty, the investor can then sue the government directly in investor-state arbitration, bypassing the courts entirely. So rather than go as any type of domestic citizen or company might do through a domestic court procedure, foreign investors under the treaty, multinational companies, can use this arbitration mechanism to sue a government. Often the disputes are behind closed doors, which is why many people don't know about these treaties. I can tell you many of my friends have no idea what I'm working on. So many of the disputes happen behind closed doors, and they're also very expensive. The average cost of litigating a case is now $8 million. And I think that was probably from 2010. I think the number is probably higher. And damages can be huge. They order, if you've got, for example, a dispute under the WTO and a state is found to be liable, the remedy is generally that you remove the offending measure, but you don't have to pay damages. Under these investment treaties, the investor can get compensation directly. So you've seen Ecuador was ordered to pay Occidental $1.8 billion. So the awards can be massive. Not all of them are that big, but they can be significant. So that is what investment treaties do, and what some of the critiques of them are is this direct right of action against the government. So, I think that they have the potential to promote sustainable investment and to catalyze flows of investment into countries and promote development. But right now, the models that are being used are not living up to their potential. And I think there are a number of reasons for that. And one is the way that the standards are being interpreted and applied. As Gustavo said, the treaties can contain vague wording, such as one core obligation to provide fair and equitable treatment. And the way that's been interpreted has been, I would argue, very strict on governments. So what I've been looking at is the extent to which this fair and equitable treatment standard in the investment treaties hinder governments' abilities to change laws and regulations for the public benefit, but in ways that might negatively impact a company. So, for example, when a government changes its tax regime, when it imposes new environmental regulations, when it changes its labor laws, when will it have to actually compensate the company for doing that? Or when will the company have to bear those costs itself? So looking at how the investment tribunals deciding these cases come out on those issues, and then comparing that with how domestic courts have treated those issues. Because these are issues that domestic jurisdictions have been struggling with for hundreds of years. So it's not new questions. And what I compared is how U.S. courts would treat these issues, looking at U.S. courts because it's generally considered to have strong property rights protections, looking at how U.S. courts would treat these issues and then comparing that with how tribunals do. And what I do see is that investment tribunals have been holding governments to a higher standard of conduct than domestic courts in the U.S. And this then requires governments and the public to bear a greater share of the risk and costs of public interest and regulatory change. And this has implications for countries such as Ecuador, who have found themselves being sued under these investment treaties before investment tribunals. And so I want to talk about just highlight some cases in the U.S. and some doctrines in the U.S. and how those have been applied, and then contrast that with some of the cases that have been brought against Ecuador under investment treaties. So in the U.S., you've got a couple important principles that shield the government from liability. The first is the Sovereign Acts Doctrine. And the Sovereign Acts Doctrine is that this rule says that a government is not going to be liable for acts of general applicability in the public interest that are taken for a public purpose, even if that impacts an investor-state contract or an investment. But that's the general default rule, is that there's no liability for sovereign acts. The second key doctrine is the unmistakability rule, and that is an exception to the Sovereign Acts Doctrine. And it says, if you as the government promise a company that you will not raise its taxes or you will not impose a new environmental requirement on it, if you make that promise in an unmistakable, clear way, in a legally binding way, consistent with all domestic laws, you will then be bound by that. And if you later change your law in a way that hurts the company, you will have to compensate for it. So you've got the general rule of sovereign acts defense, and then this exception for an unmistakability doctrine. And I'll give an example of how this was applied. I mean, these doctrines have been around for a while. So in, I think, the late 19th century, there was a case where the U.S. government, one of the legislatures promised an investor who was building up a municipal water services facility, promised them to forever exempt the facility from state, county, and city tax. Well, about 10 years later, the state enacted a lot of taxes, new taxes. The company didn't pay and said, you exempted us forever from all of these taxes. The company didn't pay, so then the state seized its assets and said, well, you didn't pay, so now they're ours. The case went up to the Supreme Court, and the Supreme Court said, look, when the legislature passed that law, it intended to forever exempt this company from taxes. But it didn't necessarily promise to never change that law. And so it was very deferential to the government and allowed it to change the law. And I found that that was a very striking case, and I think that's one of the more extreme examples of deference to regulatory change. But you've seen the U.S. courts do that in a number of circumstances where, in particular, the issue relates to taxation power, to the ability to change rates and tariffs for public services infrastructure, and the government's ability to react to certain crises, like new environmental risks that are discovered. The Deepwater Horizon raised some cases relating to these issues, too. So the courts are pretty deferential. And then a third important rule then is this notion that you can't apply the doctrine of estoppel against the U.S. So if I, as a government actor, promise a company that it will not have to comply with new environmental laws, if I don't have legal authority for that promise, later on the government is not going to be bound by it. There's not something that the company can't say, well, I relied on your promise, and even though your promise wasn't legally binding, I relied on it, so I'm still going to be able to enforce it against you. The courts in the U.S. say, we're not going to bind the government to promises made by rogue actors or people who don't have the authority to make these promises. They have to be done in a proper way, in accordance with law, and that's the only way that they're going to be binding. So those are the main contours of U.S. law. You've got the Sovereign Acts Doctrine, the unmistakability rule, and the rejection of estoppel against the government that really shield the government from liability for regulatory change that impacts operation of a company. And this has enabled the government to be able to change tax laws, tariff structures, royalty rates, environmental and social standards without having to compensate businesses for the costs of those changes. So what we see in investment arbitration under the treaties is much different. They've been much more willing, I'll step back a bit. The cases there are about 600 cases now, and there's no system of precedent. So that means that one tribunal can do one thing and another tribunal can do something entirely different. And so if I can give an example of what I'm supporting, and someone else might say, well, there's an example where the tribunal didn't really do that. But I think for states and thinking about the system, it's important to think about also the worst case scenario, because when you get sued by an investor, you're going to have to defend it, and there's always a chance that the tribunal is going to go the wrong way. So I really am kind of raising the worst case scenario decisions, but they do happen. So I would say that they've been generally much more willing to find that investors have a right to be protected against the risk of regulatory change, and they have a right to be compensated for that regulatory change. Tribunals, they don't always require the promises made by governments to be legally binding, or for the promisor to have the authority to make the promise. And they don't require that the promise be clear or unmistakable or public. So instead, what tribunals have done is that they have inferred a promise or a commitment against regulatory change from statements or representations made by government officials, even if the official didn't have the authority to bind the government to that promise. Tribunals have also inferred the existence of these promises from the general legal framework, saying that the investor has the right to rely on the stability of that framework, and should the government wish to change the laws, it should have disclaimed that intent at the outset. Tribunals have also not been concerned about whether the promise to be protected against legal change was legally valid, or, as I said, whether the official giving the promise had the authority to do so. So they allow the doctrine of estoppel to be applied against the government. So if I, as an actor, promised this company that it didn't have to comply with the environmental laws, even if I had no ability to give that promise, then that company can then use an investment treaty to say, well, now I'm exempted from this environmental law because this rogue actor gave me that assurance. So I'll highlight two cases in which these situations arose, and both involve the same claimants, the same respondent, but under different facts, and both were against Ecuador, and both were brought against Ecuador by Occidental. So in the first case, it was Occidental versus Ecuador, decided in 2004. And there, the government had enacted a tax law in 1999. It was around 1999, they enacted a new tax law, and Occidental was subject to that. And then there were some different interpretations of that tax law over the ensuing years. Occidental challenged the interpretations under domestic Ecuadorian law and wound up losing some of the cases, not all of them, but some of the cases, and then wound up challenging them again before the tribunal. And what the tribunal said is that Occidental had a right to a stable tax regime and not the changes, and said there's an obligation under customary international law not to alter the legal and business environment in which the investment has been made. So that stands in really, I think, direct contrast to the sovereign acts rule that you would have in the U.S., where there's a general presumption that the laws are going to change. That the presumption is not for stability, the presumption is really for change. So the second case is Occidental versus Ecuador, and that one was decided in 2012. And there, the tribunal cited representations allegedly made by a representative of Petroecuador during contract negotiations for why the investor had the right to expect that the tax regime would not change. They said that representations made by someone from Petroecuador caused this reliance felt by Occidental that the tax regime would stay the same, and therefore when Ecuador later enacted a windfall tax regime, then Occidental had the ability to expect that that wouldn't apply to it. So that was a case where there was an actor making some kind of statement, probably not binding under domestic law, but that the tribunal seized on in order to exempt Occidental from those taxes. So I think if you look at the cases, and these are just a couple of examples, and I could cite many other ones, if you look at the cases and you compare U.S. courts' deference to government actions with what the tribunals are doing with governments, I think it raises a question of how you want to allocate the risk of regulatory change, private rights versus public interests, and where those decisions should be made. Should they be made in a domestic forum where in legislatures, in courts, where the government actors are more accountable to the public, or should they be made in an investor-state arbitration where people generally don't have access to the cases and the decision makers aren't accountable to the public? So it's I think a major system-wide question of how these decisions should be decided and how you want to have the allocation of rights and liabilities. And I think I would say that the tribunal's decisions in this sense, they do they risk having a significant impact on government policy space. I think they override domestic choices regarding the allocation and strength of private property rights, and they hinder really the ability of investment treaties to be seen and used as tools that do advance sustainable development. So I think that comparative approach is insightful for that. And there's also, if you're interested, have a paper on our website that discusses the cases in more detail.
Okay. Finally, Julian.
Great. Well, thank you very much. My talk builds really directly right on what Lisa just said, so I'll avoid all of the repetitious parts, hopefully. But maybe my talk will be a little bit more abstract. So I want to have a slightly different focus. I focus on the use of this regime to empower private business corporations through and within public international law, especially over the last couple of decades that are most of interest here. So my goal is really to expose the emergence of the multinational corporation as an autonomous lawmaker through its selective engagement with the manifold of bilateral investment treaties, BITs, foreign free trade agreements, and the European Convention on Human Rights, even, surprisingly. So, but for present purposes, because it's more interesting here, I'll focus on the international investment law aspect. In other words, the principal regime for the protection of foreign property under international law. So I've titled the talk Corporations as Lawmakers. And what I really mean to highlight specifically is the multinational corporation's emergent capacity to make international law through what's called a modern internationalized power of contract. So I'm not concerned with things you often hear about, indirect lawmaking through influence lobbying, or what's sometimes called soft law or informal lawmaking, standard setting by industry groups that are incorporated through courts, blah, blah, blah. I really want to focus on direct formal lawmaking by agreement with sovereign states. And so my argument is that through creative treaty shopping, corporations can today attain robust property-style protection of the kind Lisa just mentioned, specifically for their contracts with foreign sovereigns. And as international legal instruments, these contracts, as quasi-property entitlements, have priority over later in time conflicting national laws, including public law and regulation. So as a result, the corporation really has to be understood as something more than a mere domestic actor. It has to be understood as a true international lawmaker whose private agreements with foreign sovereigns yield dramatic consequences for domestic public law. So what are the stakes of all of this, if it's not obvious? This radical transformation of the corporation from an essentially domestic legal person into an international entity with the capacity to actually author the rights that it's subject to can only be really weakly grounded in state consent. It's often said it comes out of the treaties that states signed, but it really only comes out of a sort of very loose treaty system, and I'll explain a little bit more, loose treaty provisions. But it comes at a stark cost, a very clear cost, to the state's capacity to regulate in the public interest. A cost felt acutely by developing countries, like Ecuador especially, but no less real and potential for the developing countries, which provides some hope for amending these treaties in useful ways. It's also important to note that these powers come basically unchecked, without much in the way of commensurate safeguards on the international level. So corporations have attained a lot of power under these treaties, but no responsibilities. In fact, not even the capacity to bear responsibilities, because they're not formally usually recognized as international legal persons. So, assuming that I have as much time as I hope that I have, I want to just really emphasize two things. This transformation of the corporation has completely undermined two essential premises of public international law as relates to business. One, that all contracts are essentially governed by the law of some country, and two, that the corporation is essentially a creature of some country and is best regulated by national states and national law. The reason why we don't make corporations subject of international crimes, of international responsibility for various things, is we think the domestic state can best do this. And I want to suggest that we've already gone quite a bit of way from that position, and so we should start thinking about the more public approaches that we've avoided so far. So it takes 3 steps. How has this situation emerged? And I'll try to get into that most of all. It's emerged through 3 developments in the law of international investment law doctrine. One, regarding the status of contracts. The second, on the type of property protection involved and associated with these contracts. And third, the law of corporate nationality and the ability of corporations to forum shop for treaty protection. So let me just give the whole picture in the abstract. The idea of making law by agreement is really familiar in public international law, where the archetypal legal instrument is a treaty, binding only on the state's parties. No one would ever say a treaty is merely a private agreement between states. It's really a form of public international law, and it has dramatic effects on the populace of both of those states. So it's important to understand that treaties have dramatic effects on national peoples, and that treaty breach can't be excused by domestic law of any kind. Yet we don't normally conceive of domestic contracts as law, at least not lawyers in common law countries. Civil law countries treat it a little differently. It doesn't really matter semantically what we call them. What we care about when we look at contracts is that they really govern the relationship between two parties, or however many parties to the contract that they are. They don't have normative legal effects on the populace as a whole, usually. So I want to argue that internationally protected state contracts occupy space somewhere between the domestic contract and the international treaty. The key point is that despite appearing as a merely private legal instrument in form, the corporate sovereign contract, its status as a heavily protected international legal instrument, significantly inhibits the contracting state's domestic regulatory freedom in a lot of the ways that Lisa has mentioned. And such contracts regulate the relationships between the parties, but at the same time create a powerful impediment on the state's capacity to regulate in areas including taxation, public health, environment, management of national emergencies shouldn't be ignored. You'd think that they wouldn't have an exception for that, but apparently not. So the key is that these dramatic public effects arise out of the implicit fusion of international contracts with domestic property theory, reaching far beyond anything tolerated in any municipal legal order of property. So let me get into the specifics. The startling image, I take to be quite startling, image of the multinational corporation as an international lawmaker arises out of the confluence of three seemingly disparate trends that I mentioned before. Recognition that state contracts are entitled to treaty protection at all, the entrenchment of an uncommonly robust level of property protection, and the non-obvious association of that protection to the contracts, because usually we think of these as different regimes, contracts and property. And third, the recognition that multinationals can alter and supplement their nationality at will to take advantage of treaties that might otherwise be unavailable to nationals of their home state. It's important to keep in mind one thing throughout all of this, though. This state of affairs is not something that's simply produced by consenting states who may or may not have foreseen all of the implications, and they might have missed a few things, but they basically agreed to this system through their investment treaties. It's emerged through a dynamic complex of action with three main actors: the states themselves, but also international arbitrators who are not accountable, and there's no system of appeal, as Gustavo mentioned. And then third, corporations who, in pursuing the profit motive, as of course you expect them to do, and can't really complain when they do it, in maneuvering around these treaties to try to accomplish more, greater, and higher profits at all times. But none of these developments really are clear consequences of any of the treaty provisions we're talking about. And I don't want to get too much bogged down into the technical details, but what should be clear is that the 3 or 4 words, fair and equitable treatment, shouldn't necessarily imply that a contract between a state and a corporation should be entitled to a more robust form of property protection than any state property regime would know. And that's all you get, those 4 words, fair and equitable treatment. It gets interpreted into this massive entitlement by unaccountable arbitrators. So it's important to understand that the whole time you'll always hear that this is a product of state consent, but that's something we should really challenge. So the first development, the form of lawmaking through an internationalized power of contract. It's something that in the oil arbitrations in the 70s we sort of flirted with in some arbitral systems, but it really didn't enter the mainstream until the modern bilateral investment treaty era. The modern mechanism really lies not in general international law, but through operation of a web of very specific treaties between states for the protection of foreign investments, and not just bilateral investment treaties, as I said, but also human rights treaties, which we think of as much more favorable to rights, sometimes are used in this way. And all of these treaties, the lowest common denominator is that they grant states certain very ambiguous protections, investors certain ambiguous protections, and give them the tools to directly enforce those protections through binding international arbitration. The treaties are at their core instruments for protection of foreign property, but they've been extended to contract protection in a few crucial ways, with the result of converting qualifying investment contracts into instruments of international law. So whether we use the terms internationalization, treatification, whatever it is, none of these terms are ever in the treaties. The key point is that these treaties insert qualifying contracts into the international legal hierarchy and insulate them from breach by contrary domestic law of any kind. And that's really the core point, because you really wouldn't expect, even in a domestic system, a contract to trump, I don't know, public legislation. So I'll avoid getting into the specifics of exactly how they do this. I'm happy to answer that later, but it's a long story and it's complicated and it's never the same because, again, the tribunals are always different. But the key point is that as long as a state contract can be characterized as an investment, which most can, short of maybe a sale of goods treaty, according to basically most of the treaties, these contracts will be given the full status of protection under fair and equitable treatment, whatever that means. The problem is that whatever that means doesn't get filled in from contract law. It doesn't get it gets filled in, not really explicitly, by a sort of second development in international investment law, a theory of property protection that's incredibly strong. And again, I won't get into it too much, but it's important to note that it's not just a problem that this level of property protection is incredibly powerful. It's a secondary problem that it's then ascribed to the protection of agreements between states and international actors, investors. So rather than reiterate all of these nice points that I had on the problems with property protection that Lisa has already covered completely, I'll turn to the third trend. That even accepting that corporate sovereign contracts are really best understood as a source of international law, it doesn't necessarily follow that corporations should be understood as autonomous lawmakers. And it sounds like a theoretical point, but it actually has pretty important implications. So, the objection would be a corporation exists by grace of a particular state's law of incorporation, and it gains access to the international treaty protection only by operation of its state of nationality's treaties on foreign investment. So to the extent that state contracts are a source of law at all, one might be tempted to view the corporation's lawmaking capacity as merely derivative of or delegated by its state of nationality through its home state's network of treaties. But I want to make clear that the corporation's capacity to make law through these contracts can't be reduced to a merely derivative or delegated power dependent on the treaty arrangements of its home state. The multinational corporation's flexible form allows significant leeway to acquire treaty protection for its contractual commitments far beyond the scope of the treaties ratified by its state of nationality. And the secret lies in its capacity to alter its nationality by simple reincorporation or even incorporating wholly owned subsidiaries to take advantage of an enormous range of investment treaties to which the parent corporation wouldn't otherwise have access. And this is basically 100% clearly recognized in the doctrine that they can do this, which is very rare in investment law. So a series of arbitral awards in the last decade basically said that they indicate that tribunals are deeply unwilling to look through corporate subsidiaries in assessing whether they qualify as nationals of a state party to a particular bilateral investment treaty, absent extreme abuse. But that doesn't really happen very much in law. So just as an example, to use another state not present here, even though the United States has no bit with Venezuela, a U.S. corporation can easily attain international protection for its contracts with Venezuela by simply structuring its investment through another state, like the Netherlands, who has a very, very, very nice set of bilateral investment treaties, very protective ones with the Netherlands, with Venezuela and many other states. It's something affectionately called the Dutch sandwich by lawyers who work at law firms that do this, which I may have worked for myself. So the trick is, though, you don't have to structure your investment in that way in advance of actually making the investment. Chevron can create a subsidiary, can create an investment contract with Venezuela, and then maybe they get the sense that Venezuela has been expropriating some other people's things, as they do sometimes, and then say, okay, well, I see the writing on the wall, now we're going to reincorporate and literally unilaterally change the law of the contract from whatever it was originally, let's say Venezuelan law, to international law, whatever that means. So it's pretty amazing that they can do this after they've actually made the investment. And you have to understand it's a unilateral thing. Only one party has the right to decide ex post what the law of the contract is, with major effects, because if the contract was just under Venezuelan law, you wouldn't get all of these robust protections, property-style protections. Once Venezuela breached that contract, you'd get whatever Venezuela said. As soon as you internationalize it and send the thing to international arbitrators, the story's very, very different. So I assume I only have about a minute, so I'll sum up. If the form and the substance of corporate lawmaking comes from a blend of contract and property ideas, then what I'm suggesting is that the autonomy of the corporate lawmaker arises out of arbitral doctrine on the law of corporate nationality. The full image of the corporation's status as a lawmaker in international law doesn't really come into focus through analysis of any of these trends on their own. And these trends aren't really viewed together very often. But taking them together, we see a much more recognizable image. At least within the ambit of the pre-existing web of international investment treaties, the corporation appears as a basically autonomous actor empowered to make and directly enforce international law with major effects on the domestic regulatory freedom of its contracting partners. And there's a lot of problems with this. I'm happy to talk about them more later, but the main three are, first, that we should be much, much more suspicious of the level of property protection that's given rise to this situation. And second, we should be especially suspicious about associating that level of property protection with state contracts. And third, although it is a rarity in investment law to find consistent doctrine on corporate nationality, we should be suspicious of the idea that one party would be able to change the terms of the contract unilaterally for reasons outside of that contract, simply by reincorporating in another state. There's a lot of other problems, but I'll leave it to another day. Thanks very much.
Well, thank you very much, the three of you. I'd like to pose a question for the three of you, and it's basically also taking some of the inputs that you have already mentioned. So recognizing the potential that the role of FDI has in terms of achieving sustainable development and economic diversification, and at the same time breaking the natural dependence on the natural resources dependence, and even enhancing the transformation of the structure of the economy in developing countries. So recognizing the potential that FDI has on that side, but at the same time, recognizing all the challenges that you have mentioned in terms of the investment treaties and in terms of the international arbitration systems. And just to mention some of them, you have mentioned the ambiguity in the interpretation of the standards. You have mentioned several flaws that the international arbitration system and the procedures it follows has, and that sometimes even put in risk the sovereignty of the countries when they want to apply public policy. The question is, what do you think that might be the next generation of domestic and international investment law and policies in the future? So I don't know if...
I think you should answer.
Okay, well, I mean, it's a good question, and I think there's a lot that can be said. I would say the regime should look more like a political risk insurance regime. The treaties are designed to allow investors who are feeling a little bit nervous about investing in a different jurisdiction to have a degree of comfort about the host state's legal framework if they don't know it or don't feel like they can trust it. Political risk insurance has been around for a while to serve that same goal. There are a couple of differences, though. One is when you get political risk insurance, you have to pay a premium for it. Investment treaties, you just get it for free. Another thing is when you get political risk insurance, the underwriters look at your business and they look at the host country and they price it accordingly. So the host country is incentivized in a way to behave well so that the premiums are low enough. And the investor is also incentivized to have a good business model so that insurers think that it's a worthwhile enterprise to provide insurance for. And when something goes wrong and the investor makes a claim, the insurers look at the investor's conduct and the degree to which the investor has contributed to the losses. You don't have that same degree of scrutiny of investor conduct in the investment treaty system, that it's generally they scrutinize the host state's conduct but don't really scrutinize the investor's conduct. I think that's a gap. And you also have under political risk insurance exhaustion, and you don't have that under the investment treaties. An investor can go straight to arbitration, challenging the conduct of a lower level official in the host government. So I think there's a lot that we can learn from political risk insurance. And I think it's interesting that if an idea behind the investment treaties is that they're supposed to give investors comfort, and that investors lack this comfort, and if they had this comfort, they would invest much more abroad. Only 10% of FDI worldwide is covered by political risk insurance. So that means that really capital investors are only securing coverage for 10% of their investments. So this uncertainty about the host country climate, I think, is a bit overstated, because if there really were that uncertain, people would be getting a lot more political risk insurance. So these treaties, I think, are a free way of getting protection for a broader set of protections available under political risk insurance. And they don't have any of the same level of scrutiny for investors. So I would move it that direction. I think it's got to be more of a system that looks like that.
Yes, but there are also other recommendations, you know, that have been. The other one will be contract-based arbitration, just for specific cases, or maybe private contracts. Instead of signing investment agreements, will be, you know, the development of private contracts between the country and their specific corporation that is investing in the country. And actually, in Ecuador, Ambassador Sela, when she was Minister of Coordination, they have a new code, and in the new code, for treating investment, you know, they propose that already, you know, private contracts, you know, with corporations in specific cases. Yeah.
Okay. Would you like to add something?
Sure, yeah. So I maybe have a slightly different or complementary view. So I actually don't really hate investment treaties. I think that they have a lot of potential. The problem is largely the way that they've been interpreted in very unaccountable ways. And so, you know, there's been a lot of empirical work on the question of whether they actually encourage FDI or not. I don't know. I'm not an empiricist, and I'm going to stay out of the policy question. But I think that they actually could do quite a bit to encourage foreign direct investment in an equitable and good way. The issue is that I think there's a lot of room for states to take hold of the interpretive process, and I know this is something we've talked about a lot. There are a lot of different mechanisms through public international law through which states can assert their views of their treaties. States are supposed to be masters of the treaties. And actually, there's probably not that much difference between capital importing and capital exporting states on a lot of these interpretive issues. Because if you look at the NAFTA context, the United States is not wild about corporations running around telling it how to, you know, run its regulatory policy either. So the distance is not as great, and therefore simply leaving the regime or trying to withdraw from these treaties might actually politicize something that doesn't need to be politicized. So through mutual interpretation and more informal tracks, I think we could actually get pretty far. But I also want to emphasize one other thing. I don't think the answers are only in domestic law and the specific international law of foreign investment. There's more out there in general international law that can help quite a bit. So on the issue that I've been talking about, if the corporation is now suddenly empowered through investment treaties, then general international law should begin to be applied to them, and states are responsible for determining to what extent that's possible. So, for example, they should be subject to the same human rights strictures that we expect of everybody else, and there should be mechanisms for their accountability. So, you know, there are tools outside of investment for mediating the problems with the investment regime, and we haven't really done a very good job as a community of making use of those tools.
Okay. Does anybody has a question for the panelists?
What would the forum be for the changes that you suggest? Address the, can you hear me?
Yeah.
Yeah. What would the forum be for the changes that would embrace the recommendation?
It depends on which of the changes. If we're talking about the interpretive moves, okay, that's the one that there is a forum for, thankfully. There's
Even the ones that aren't.
Sure,
Okay.
sure.
And what would you suggest?
So I would have to make a couple of different suggestions. One thing depends on what kind of treaties we're talking about. The NAFTA actually has interpretive fora explicitly for the parties to get together and issue interpretations. But other fora include the internet. As long as the states both post in their official capacity what they take to be the view of the sovereign state of Ecuador, the sovereign United States, on a particular treaty, if those coincide under the international law of treaties, that is evidence of the parties' agreement to interpret that treaty subsequent to its initial promulgation. And those interpretations can go as far as a modification of a treaty. It's been recognized by the International Court of Justice time and again, and other international courts, that you can go really far with this. So what you're looking for is not necessarily a forum, a formal forum, but rather evidence that the parties, through their conduct or agreements, agree. And you can do that through any forum. So it's actually quite flexible.
If you don't have precedent doesn't exist, could there be a vehicle, I don't know what that vehicle is, to at least, create the parameters on a level, multilateral level, within which you could have the kind of tweaking adjustments that would start to set standards rather than a hodgepodge, if you will.
Sure. I don't want to hog this topic because I know Lisa's just as interested as I am, and I think we'll have the same answer.
The anti-trial thing?
The what?
The anti-trial
Sure.
change? I don't know if you were going to say the same thing, but UNCITRAL, which is the UN body that has developed a set of arbitration rules to govern these proceedings, they are in the process of negotiating a convention to ensure transparency of the dispute. So the way that is going to operate is if two state parties sign on to this transparency convention and both of them are also party to the same treaty, then that transparency convention will govern them. So that will be a way that different states can sign on to this reform. And you could think about doing the same for creating an appellate mechanism or for inserting maybe an exhaustion requirement. So you could do that for other systems, but that's one effort.
The one thing I would caution, though, is while multilateral solutions are great and really important, given the lack of political will to actually easily make a simple multilateral system, so we accept that, then what do you do? I don't mean to say that it's easy to then come to multilateral or broad-based global solutions through interpretation, because each of those interpretive moves has to be done with regard to each specific bilateral investment treaty. So it's kind of a nightmare, but it's a nightmare worth seeing through to the end and the other side.
Ambassador? And Esteban. Yeah. Okay.
Can you tell us a bit more about how these treaties come about? You mentioned there's about 3,000 of them active. Are those traditionally the result of lobbying by certain industries? For example, the oil industry in the U.S. lobbies with the U.S. government for the U.S. government to sign a treaty with Ecuador. Or do these treaties come about more from developing nations seeking to negotiate the terms to bring in investment from developed nations? And given that distinction, and the fact that you mentioned that there is no empirical data to conclusively say these treaties promote foreign direct investment, if that distinction is made, then is there a closer correlation of effectiveness to attract investment?
I would say I think a lot of it does come from business interests. So, for example, Canada in this past year negotiated 9 investment treaties in Africa, and it is home to 75% of the world's mining companies. And so I think that there is definitely developed country, capital exporting state driven, but developing countries for a while were very receptive to them with this idea that it would lead them to attract additional investment. But as the statistics on whether or not that actually happens has become, that assumption has become more in question. I do think you see developing countries maybe less interested in signing them. But, I mean, I don't know, but you still see them. I think at least some of the African countries, they also want, for example, investment in their extractive industries. So they're excited about the prospect of Canadian investment. So even if it's not certain that it will lead to investment, I think they're willing to take the chance on it. Especially, I mean, until you see their statistics that until a country gets sued, that it's all about the possible reward rather than the possible risk that people are thinking about. And then once they start to get sued, then the rate of negotiation drops off. But until then, it's, it's upward.
Okay, so we have time for a last question and a last answer. Okay, go ahead.
Well,
Well, I have a question for Professor Dominguez. What would you say that will happen if one of these 26 denounced treaties, as you mentioned, they have a provision clause that is named the survival clause, and they last for around 15 years, depends on what treaty it is. So what will happen if a conflict arises from a company that was already in Ecuador? And in this case, what would be the conflict with the legal framework, basically with Article 422 of the Ecuadorian Constitution? And also, how would you relate this to public international law?
Well, the thing is, this clause maintains, for so many years after the agreement has been denounced. So even though if Ecuador denounce agreements and fulfill all the process of denunciation, it will have to be, it will have to wait for those 15 years before the Ecuador is no liable. So that's how international law goes. So that's the frame of the denunciation of the bilateral investment treaties or the multilateral investment treaties. So Ecuador will have to go for those 15, 20 years in some cases. Yes.
Julian would also like to add something.
Just to add to that, I mean, that's just another reason why interpretation is a crucial and much more effective mechanism, because you don't have to worry. If you interpret away all of the really bad problems with it, then you don't have to denounce the treaty and have these
Absolutely.
issues.
Yeah.
Okay, thank you very much. Right now we're gonna have lunch. So, yeah, and we will wait you here at 2 p.m. in order to continue with the other panels. Thank you very much.